So Mike Smith is suing 7 major emitters for climate harm. And in February 2024, the Supreme Court said that Mike's case was allowed to proceed to full trial. This trial was supposed to start in April 2027. But these polluters don't want to go to trial, and they don't want to stop polluting. Instead, they wanted Parliament to just change the law so that this case cannot continue. Focus in on this 2024 timeline. 7th of February, the Supreme Court allows Smith v Fonterra to proceed. The 23rd of February is the first recorded ministerial advice to Paul Goldsmith about a legislative response to Smith v Fonterra. That is just over 2 weeks after the judgment. Then, on the 6th of March, the then Attorney General Judith Collins writes to ministers proposing that, quote, the option of a statutory bar on climate change tort proceeding is the most straightforward response. This government has never once considered it urgent to prepare a response to actual climate damage or climate change. What this government felt in crisis to respond to is possibly the same reason the Supreme Court let it go to trial. This case is so important because it might actually create a legal opening in the courts to be able to develop the common law that is appropriate to allow major emitters to be held responsible for climate harm. The law is not fixed. It develops through court decisions. If Mike Smith won his judgment, that could become what's called in law precedent, meaning that other people could bring similar cases and more judges are likely to respond the same way against major polluters. When she says most straightforward way to respond, she is comparing the ways the government could stop climate tort proceeding. Big polluters have spent most of the last century buying politicians, trying to win big cases to set precedent that suits them. A Smith win would swing a wrecking ball through decades of carefully manipulated legislation and case law that was built through corporate lobbying to protect polluters from the people they harm.